Good morning, everyone. Welcome to our webinar called New Connecticut Employment Laws, Compliance Priorities for Employers. My name is Andrew Walsh, and I'm a partner in Verril's Business Law Group based out of its Westport office, where I focus on corporate and commercial transactions. Today, I'm joined by my colleagues from our Labor and Employment Group, Tawny Alvarez, Eric Peters, Elizabeth Johnston, Hannah Owing-Satterley, and Cyrus Cheslak. Connecticut employers are facing significant new compliance obligations following recent legislation, including changes related to pay and benefit disclosures, overtime notifications, accommodation requirements, employment agreements, and the use of artificial intelligence in employment-related decisions. During this webinar, we'll break down these new laws and provide practical guidance on updating workplace policies and practices to meet Connecticut's evolving legal requirements. Before we get started, I'd like to share a few quick housekeeping notes. For those of you who are new to our webinar series, today's program is being recorded. A recording and copy of the presentation slides will be emailed to you in the coming days. This webinar has also been approved for 1 CLE credit and 1 SHRM credit. If you're an attorney admitted to practice in Connecticut, we will send you a certificate that you may submit for CLE credit. If you are admitted in Maine, we will submit your name to the Maine Board of Bar Overseers for CLE credit. If you have any questions during the presentation, please enter them in the Q&A box, and we will do our best to answer them in real time. Thank you for joining us. Let's begin. As a corporate attorney, I would like to stress that these new compliance obligations also have impact beyond the employer-employee relationship. For example, in the context of transactional matters, such as M&A transactions, the target company will be required to make representations and warranties relating to compliance with applicable laws, or in loan covenants, which require ongoing compliance. Accordingly, complying with these new laws would serve to avoid any snafus which could arise during an M&A partner's due diligence and negotiation of a transaction. Now, first up is Tawny Alvarez, who will begin with what constitutes hours worked and electronic surveillance of employees. Tawny?
Thanks, Andrew. Before we get into specific elements of hours worked and security screenings, we're going to just give a quick outline of what you can expect from today's presentation. For those of you who have joined us before, you know that I never like to have people attending a webinar if they think they're going to get information about one topic and ultimately don't. So, outline of things we're going to go over today include hours worked and employer security screenings. We're also going to talk specifically about electronic surveillance of employees and the new statute that has amended Connecticut's old statute and new standards you're going to have to put into effect. We're then going to jump to employment promissory notes and training repayment rules and how those have been clarified. We're then going to discuss lactation accommodations and statute that was passed this year that goes into effect, notifying employees regarding rights to reasonable accommodations. We're then going to provide a pay transparency update, and then we're going to spend a good chunk of time on Connecticut's new AI employment law. So we're going to do some initial labor and employment matters, then we're going to do a big chunk of time concerning the new AI employment law, and then we're going to discuss two recent task forces that have been created, the Workplace Heat Safety Task Force and the Minimum Wage Task Force. So with that, let's jump to the next slide concerning hours worked. So earlier this year, so in February of 2026, the Connecticut Supreme Court issued an opinion in Del Rey versus Amazon.com Services, Inc. And this was a case that was being heard at the Second Circuit. And the Second Circuit certified a question to the Connecticut Supreme Court concerning the definition of hours worked under the Connecticut wage and hour law. So Connecticut wage and hour law, the definition for hours worked is included in statutory section 31-76B2A. And there, it noted that hours worked included all time during which an employee is required by the employer to be on the employer's premises. So at the Amazon distribution center, there was security screening that every single employee had to go through at the end of a shift. So at the beginning of a shift, they would walk in, no security screening required. They would put their items into a locker room if they wish to, and if they brought items, and then they would clock in and begin work. At the end of the day, they would clock out, go to the locker room, collect any of their belongings, and then go through security screening. Now, oftentimes security screening took between 10 and 20 seconds, but in some situations, if people had bags or there were additional issues with the security screening, it could take up to 20 minutes. So there were 3 lines at the facility, one for people who had absolutely no personal effects. They would just walk through a metal detector. A second line for people who had things in their pockets, and they would need to empty their pockets, put it in a little bin, walk through the metal detector, collect the things on the other side. And then there was a third aisle in which people who had lunch pails or backpacks or purses, in which those purses or backpacks needed to be put through an x-ray machine and scanned through that process. And if there was a hit, if it wasn't a clear screen, they would then go to another section and they do a wand screening, similar to at the airport, right? So the question is whether or not the time that it takes to go through this screening process is compensable under Connecticut law. Under the FLSA, federal law, it was determined that nope, this meets the de minimis exception. This 30 seconds to a minute time frame is non-compensable under the FLSA. But the question was whether or not it's compensable under Connecticut law based off of that language, right? The hours worked is time in which a person is required to be on the employer's premises. And here they were required to go through the metal detector when they left. And the Connecticut Supreme Court said, yes, this is hours worked under the statute, and employees need to be compensated. So they shouldn't be clocking out until after they have gone through the security screening. So some of the employer takeaways from this case was to review pre and post shift requirements to determine whether or not individuals should be compensated for the time that they're going through security screenings, whether at the beginning of the shift or at the end of the shift, and reviewing your compensation practices to make sure that they are in line with the decision in Del Rey. Now, this came out in February of 2026, but if we go to the next slide, the Connecticut legislature did exactly what we hope it would do, and that is that they took the Del Rey decision and they codified it. And the codification occurred in Senate Bill 345, and it added an additional section to the definition of hours worked and clarified that it includes time an employee spends in security screening is included in the definition of hours worked. Okay, let's go to the next slide and talk about electronic surveillance. Now, everyone was aware, if you had Connecticut employees, that the electronic surveillance bill has been in effect for a few years now. This is an amendment to the bill, however. It applies to all Connecticut employers, and now it requires that notice be provided to applicants that security screening is going to occur. And you also must give very specific notice informing employees and applicants of the type of monitoring that you are going to use and where on premises monitor is going to occur. So it was broad previously, and now there's this specificity that is required underneath the statute. Also, posting obligations and that updated notice to newly hired. It is important to understand that if you were previously unaware that you had this statutory obligation, I highly recommend that you take a look at Public Act 2673. There are a couple of exceptions that you'll see here concerning airports and criminal investigations. And there's also an exception for self-service kiosks. So if you have a self-serve kiosk where you're recording customers who leave and that may pick up an employee's movement in some format, that is exempted from this obligation. And you could use data if you needed to evidence theft of some format concerning monitoring that's occurring in self-serve kiosks. If we go to the next slide, let's just do a really quick comparison of where Connecticut is on the spectrum of states that have implemented electronic surveillance, at least as it relates to those who are geographically close. So New York has a civil rights law, Section 52-C, which does regulate electronic surveillance of employees. And under New York law, you must give prior written notice upon hiring. So parallel now to what Connecticut's obligations are. It has to be in writing. It has to be in a form which is acknowledged by the employee, either in a written format or in an electronic format. New York law also has a posting requirements, and there's a $500 penalty for the first offense and a $1,000 penalty for any additional offenses. Additionally, there is an exception in the New York law. If you are just monitoring internet usage for computer system maintenance or protection, that is outside of the scope of New York's electronic surveillance law. New Jersey, however, does not have any employee electronic surveillance law. The closest thing that it has concerns tracking devices that are used in vehicles, and that's located at 34:6B22, and that is tracking of vehicles. And Massachusetts also doesn't have an electronic surveillance law, but instead focuses in on the two-party consent statute that they have under the Wiretap Act. So there is no monitoring statute and no obligations to provide notice under the Wiretap Act. But anytime you are recording, you need to have both parties consent to that recording. And with that, I'm going to pass it over to Eric to talk about promissory notes and training repayment.
Thank you very much, Tony. I have kind of a grab bag of topics here, and it starts off, as Tony indicated, with the changes to the law regarding promissory notes and requiring employees to repay sums advanced for training. So currently, only employers that have at least 26 employees are prohibited from forcing an employee to basically sign a promissory note or some other kind of an agreement requiring the employee to repay the employer money that it's previously paid if the employee doesn't remain at their job for a certain period of time. And that includes what are promissory notes for training expenses that the employer incurs. So starting with agreements that are executed on or after October 1st, all Connecticut employers, regardless of size, are prohibited from requiring employees to repay sums, including training reimbursements, if the employee leaves before a set time. So there are some exceptions to this, if we can move to the next slide, that continue unchanged. And specifically, as you can see there, agreements for the employee to repay money advances for property sold or leased to the employee, or for educational personnel to comply with the terms of a sabbatical leave, or if there's repayment obligations in a collective bargaining agreement in a unionized workforce, that remains unchanged, and those are going to be still allowed under the new law, even when it changes on October 1st. So if you're an employer and you think that this may affect your business, what should you be doing in advance of October 1st? Let's go to the next slide and we'll look at some action items. Specifically, you should assume, if you're an employer, that any kind of training repayment agreement provision that you have that's tethered to the employee continuing to remain employed with you is at heightened risk going forward. Obviously, anything after October 1st is prohibited. There is a risk that even existing agreements might be at risk, because an employee could, you could easily see an employee making an argument that a court shouldn't hold him to the terms of an agreement that he signed before the statute changed, because the statute change clearly evidences a policy that the state doesn't want employees to be subjected to these agreements. How much mileage that would get an employee in court remains to be seen, but there is certainly a risk of that. So in addition to that, you should be talking to your lawyers and probably your accounting and finance people about other ways you could potentially achieve this outcome without violating the statute. And so, retention incentives that are more aligned with bonuses if employees stay, prorating forgiveness in terms of tuition assistance, and maybe showing the employee, even if you're not explicitly saying, hey, stick with us, and if you stick with us for a specific period of time, there's going to be career advancement and promotional opportunities, showing them that there is a path to doing that. Those could all be alternatives now that the law is changing to invalidate a lot of these training repayment agreements. Okay, so we're going to move on and we're going to talk about some fairly significant changes to the law with regard to lactation accommodations in the workplace. So currently, under Connecticut law, an employee can only express breast milk or breastfeed during her meal or break period. The amended law expands that right to additional break times beyond those breaks that are already scheduled. Specifically, as you can see there on the slide, Connecticut employers now have to provide additional reasonable break times for an employee to express breast milk or to breastfeed at the workplace, in addition to allowing it during the employee's regularly scheduled breaks. So, in other words, the amendment and the existing law is Section 31-40W, as in West. Under the amendment to that, removes the prior requirement that lactation-related activities occur only during a meal or break period. All right, so that's what has changed. Let's look at what hasn't changed on the next slide. So the employer has to make reasonable efforts, and that's in quotes because it's directly from the statute, to provide a room or location near the work area, and it can't be a toilet stall, that is private, has or is near a refrigerator, or other employee provided portable cold storage device, or has access to an electrical outlet. That's what you have to give the breastfeeding or expressing employee. You can see there we've got the term reasonable, or highlighting the term reasonable efforts. What exactly does that mean if you're an employer? What does it mean to make reasonable efforts to provide these things? Well, if we go to the next slide, you can see that it's sort of keyed off of business size, financial resources, and operational structure. And reasonable efforts actually under the statute means any effort that would not impose an undue hardship on the operation of the employer's business. Okay, so what's an undue hardship? Undue hardship is any action requiring significant difficulty or expense when considered in relation to factors such as the size of the business, its financial resources, and the nature and structure of the operation. So, one hypothetical that potentially could allow an employer to evade these requirements or not be subject to them is if it's a one-man shop and we can't do it for that reason, one person shop, and we therefore can't provide this type of a facility for someone. It's just not logistically possible. As you can see, the law also prohibits discriminating or taking adverse action against an employee who exercises these rights. And notwithstanding that an employer or a small employer may have an undue hardship argument against having to comply with the new law, employers with one or more employees are expressly covered, highlighting the broad reach of the update to the statute. All right, so the next slide has got a ton of information on it. And that is because we wanted to sort of give you all compare and contrast as to how the new law is going to look as opposed to requirements imposed under federal law. And there are other federal laws besides the PUMP for Nursing Mothers Act. And by the way, PUMP stands for Providing Urgent Maternal Protections for Nursing Mothers Act. There are other things like the Pregnant Worker Fairness Act and potentially considerations under the Americans with Disabilities Act and Connecticut's Fair Employment Practices Act. But predominantly when it comes to breastfeeding and expressing on the federal level, it's this PUMP Act that you have to look at. So let's look at the differences or similarities between the new law in Connecticut and the PUMP Act. So first, as I just mentioned, the new law in Connecticut applies to employers with one or more employees. Similarly, federal law applies to employers of all sides as long as they're covered by the Fair Labor Standards Act. However, similar to the out in the new Connecticut law, employers with fewer than 50 employees can be excused from coverage, again, under a similar undue hardship standard to the one we just discussed. The PUMP Act expressly limits its protections to 1 year after the child is born. That's at issue. There's no durational limit under the Connecticut law. So it's the full duration of breastfeeding and expressing regardless of child's age. Federal law, as you can see, does not affirmatively states rather the break time doesn't need to be compensated unless the employee is not fully relieved of duties. The Connecticut law doesn't expressly address pay for lactation breaks, but it suggests that, as I indicated earlier, employees have the right to retain to breastfeed or express during existing break periods, along with this new right to do so outside of existing paid break periods. Additionally, both laws require private spaces that aren't bathrooms or toilet stalls. Connecticut law goes further, requiring proximity to a fridge or a portable cold storage device and access to an electrical outlet. So let's look at a couple of potential action items related to this. Obviously, update your break policies, revise your handbooks so that lactation breaks are explicitly available at times in addition to regular breaks, not just folded into them. Look at the lactation spaces you have, confirm that they comply with the new requirements under the statute, including the proximity to the electrical outlet requirement, the proximity to a fridge or employee-provided cold storage. You're going to want to obviously train your managers and supervisors on the new standards so they know what they're doing. Coordinate what you're doing with the federal, with any federal obligations that you might have, like the PUMP Act and the PWFA. And also look for any sort of lactation-specific advice or guidance from the state, from the Commission of Labor related to the new law. The changes to the statute don't expressly say that the state is going to put out a guidance or anything, as opposed to some other situations. But it wouldn't be surprising if there were regs to sort of put some flesh on the bone of some of these requirements and sort of fill in some of the blank spaces. All right, my last topic is changes to the Connecticut law regarding an employer's obligations to inform their employees of their rights to a reasonable accommodation under the Americans with Disabilities Act. You may be saying to yourself, I don't have 15 or more employees. I'm not subject to the ADA. Why do I care about this? Well, interestingly, as the law is written, it doesn't just apply to employers that are covered by the ADA. It applies to all employers, whether or not they're covered. So there is guidance that's coming out about this law. We'll talk about that in just a second. Presumably that will include guidance that says, hey, if you're not subject to the ADA, you don't have to provide notice about your employee's right to reasonable accommodation under a statute that doesn't apply to them, but that hasn't happened yet. So be on the lookout for additional guidance. But as the law stands right now, all employers have to give written notice about an employee's right to a reasonable accommodation under the ADA. You have to give it to new employees at the start of their employment, existing employees by the end of January of next year, and to an employee who notifies the employer of a disability within 10 days of the employee doing so. And so if we go to the next slide, it's actually not particularly, can we go to the next slide? Thank you. It's not particularly onerous about complying with the statute. There's literally a poster that's going to be coming out by the Connecticut DOL. And if you display that in a conspicuous place that's accessible to your employees at your place of business, that should help. Or that should, that should take care of it. A couple different little wrinkles to this, though. One, the statute affirmatively says you have to use this specific poster. Two, if you've got a largely remote or entirely remote workforce, they're not going to see it at your place of business. So you're going to want to make sure that you make sure that they get the information that they're entitled to get one way or the other when they're entitled to get it, as we saw on the last slide. So the Department of Labor may also adopt some additional regs about notice requirements. We're in sort of wait and see mode. And so the last slide on this, if we can go to it in terms of action items, if you don't think that the poster requirement is going to work for you, then make sure that you've got compliant reasonable accommodation notices that you'll be ready to distribute once the law becomes effective. And again, you're going to want to look for any implementing guidance that's issued by the Labor Commissioner, which should be forthcoming relatively soon. So that covers my topics. I'm going to throw it over to Liz Johnston, and she is going to start by talking about pay transparency updates.
Thanks, Eric. Good morning, everybody. My name is Liz Johnston. I'm a partner in the Labor and Employment Group at Veril, and my section today is going to focus on updates to pay transparency requirements in Connecticut and a few of the other states in which you might be doing business. So Connecticut recently passed legislation that's really along, I'd say, a national theme of what we're seeing legislatures do, and that's moving toward greater pay transparency and disclosures about how employees are paid, what information applicants are getting, both before and during employment. So bottom line is that in Connecticut, pay transparency isn't just a recruiting tool or recruiting issue, but a legal requirement for all employers. So the pay transparency requirements apply to everyone, no matter your size. As noted on the slide, the updates are effective on October 1st, 2026. So this is a good time to start taking steps to prepare for the updates, prepare for the requirements, rather than waiting until that deadline gets too close and risking non-compliance there. Next slide, please. So the first topic I want to talk about is a little bit adjacent to what we think about as traditional pay transparency in job postings, but this relates to Connecticut's new pay code transparency requirement. So as summarized here, this is a requirement that applies to employers with at least 100 employees. So if your organization's covered, the organization needs to create an employee pay code guide that explains pay codes used for overtime and other commonly used pay differentials. This would include on-call pay, hazard pay, holiday pay, geographical differential pay, and other similar categories that might show up on those employees' paychecks. The guide has to include at least 10 pay codes if that's applicable to your organization, and it does need to be updated whenever a new code is added for overtime or a new differential is added to the use. However, you don't need to create or establish new pay codes to be compliant with that minimum, so it's only as applicable. Next slide, please. There are a number of requirements for this guide that you should be aware of if this is going to apply to you. So first, it does need to be posted on a company's intranet or internal website if that organization has one. But the law expressly provides that you're not required to create a website if you don't already have one. That guide needs to be available in English, Spanish, and other most commonly spoken languages in your organization. And it needs to contain contact information for employees as to who the appropriate person is to get in touch with at the company if that employee has questions or wishes to dispute a pay code use or calculation on their paycheck. So it's important to identify that person and that contact information. There's also a number of notice requirements in the law. Employers need to provide employees with the website address, again, if you have one, and upon hire, and that website needs to be on the pay stubs provided to employees that include information about the pay code use and their hours worked. But the employer can comply with its notice requirements by providing a guide to employees upon hire, as long as it's given in English and the employee's primary language that they speak. For those of you that use third-party providers for your payroll services, the employer can refer to that guide published by that service provider, but it needs to be meeting the requirements of the law. And that's an important piece with that deferral, is that we can't just presume that that guide is going to be compliant. So it's important to take steps to ensure that it is, and make sure that you're referring to a compliant guide. So really this law, to sum it up, is about giving employees, again, more transparency and kind of a roadmap for understanding their paychecks and how they're coded and calculated by the employer. But this will require some coordination between your HR department, payroll, operations teams, to make sure that we get those codes kind of itemized in terms of what's being used, and create that guide before the October 1st date, and make sure it's properly disclosed to your new hires and on your website and paychecks as applicable. Go to the next slide, please. So getting into kind of the bread and butter of the pay transparency updates, effective October 1, all Connecticut employers need to disclose the wage or wage range for a position in internal and external job postings and advertisements. So prior to this law, Connecticut did have requirements for employers to disclose wage ranges to applicants if they asked for it, or prior to or at the time of the offer of compensation. So this posting update is really an expansive change that's going to create much more affirmative obligations on disclosure in those advertisements. So in terms of what needs to be disclosed, the law requires the disclosure of the wage itself or the wage range. And that's defined as the range of wages that an employer sets in good faith for a position. In terms of what that means, that's not specifically defined in itself. What is good faith, right? But it's a similar definition to what we see in other jurisdictions that have pay transparency laws. But it's not a meaningless term. It's, the range should be narrow enough where it is a reasonable expectation for the employee, and not so broad that it will invite, scrutiny unless there's a really good explanation for why the wage range is created for that position. Another important aspect of this is that the job postings must also include a general description of benefits that are available to the employee. And according to the statute, that's going to include health insurance benefits, retirement benefits, fringe benefits, paid leave, and any other type of compensation other than wages themselves that are likely to be offered with the position, or that will be offered with the position. The law also builds on some of those previous disclosures that were required. It now includes disclosure of benefits information to, again, applicants when requested, or when there's any discussion of compensation with the applicant. And there are still the existing requirements on providing wage ranges, and now including benefits to employees upon hire and when they change positions, and on request. So the bottom line is, it's not just job postings that are updated by the pay transparency law, but there are those existing disclosure elements that are still in effect, but now supplemented to include the benefits information and broadened to really occur prior to those compensation elements or discussions. The geographic reach of this is also important to note. So this includes jobs that are going to be performed in Connecticut, as well as positions performed outside of Connecticut, if that person is reporting to a supervisor, office, or work site in Connecticut. So that is especially important for those of you with remote and hybrid workforces that might be hiring employees who live outside of the state. Those disclosure requirements are going to apply to those roles and those hiring efforts, even if those employees are working remotely. Next slide, please. So I mentioned there are some, existing elements of the law. This slide kind of goes over some of those anti-secrecy and anti-retaliation elements of the statute. Again, a lot of those remain unchanged, but employers can't prohibit employees from disclosing or discussing wages, can't prohibit employees from asking about the wages of others, and they can't require employees to sign waivers related to those disclosures, discussions, or inquiries. So those remain in effect. The law also continues to provide that employers can't ask about employees' past wages or salary history unless it's voluntarily disclosed. And importantly, employers can't discriminate, discharge, or retaliate against individuals for engaging in all of the activities that are protected under the statute, right? So it also now includes a specific provision that prohibits employers from refusing to interview or refusing to hire employees for engaging in that type of protected activity. So in terms of next steps, practical advice, the obvious advice is to make sure that your job postings after October 1 are going to contain the requisite information about wage range and benefits, and making sure to have that information prepared so that it's ready to go as of the effective date. It's also a good time to look over any policies you have, confidentiality agreements you have, to make sure that those don't contain any of those prohibited prohibitions, for lack of a better term, in terms of discussion of wages. And also update your interview guides, scripts, and work with anyone involved in the hiring process to make sure that those persons are trained on and that pre-employment disclosures reflect the new wage range and benefits disclosure obligations. I also think there's a broader element of training here too, especially with regard to the anti-retaliation, anti-discrimination pieces. There are some times when managers can react negatively, or employees generally can react poorly to employees discussing wages of others, and a misconception that that's not something that should be talked about at work. But again, with all of the protections that continue to exist and are broadened under this law, it's important to make sure that folks know what's protected activity and how to address and respond to those discussions when they arise. Next slide, please. So I want to briefly touch on a few of the other states in which these requirements might apply to you as a Connecticut employer, because I mentioned that Connecticut's just one of many states that have recently kind of implemented pay transparency. It's important to note that New York and New York City both also have separate pay transparency statutes. For New York State, this is going to apply to employers with just 4 employees, and that's not just in New York. But if you have somebody working in New York, or a position is located in New York and reporting to Connecticut, you are maybe subject to the New York pay transparency law. It's a similar requirement in terms of requiring a good faith pay range be part of the job advertisement. But there's also a requirement that job descriptions are included in a job advertisement if one's available. Employers also, if you're subject to the law, need to maintain a history of salary ranges and job duties under the law. So there are some additional requirements if you are, again, hiring from or having employees located in New York. Important to be aware of that. New York City also has its own pay transparency law. Requirements are pretty similar in terms of what needs to be posted, the good faith pay range. And this is going to apply if you have 4 or more employees that are covered by New York City's human rights law. So that would be those located in New York. So perhaps a narrower subset. But the reason I wanted to flag these also is because when we have multiple agencies and multiple states with these laws that all simultaneously may apply, especially with remote workforces, it's that many agencies that are going to have their own interpretation of what a good faith range is and their own penalties, methods of pursuing violations. And New York City's law in particular provides for up to $250,000 for an uncured violation of this law. So again, it's a reminder just to be aware and be compliant with everything that might apply. Next slide, please. Along this similar vein, New Jersey also has its own pay transparency law. This is broad as well, so it applies to employers with 10 or more employees over 20 weeks per year. But it's not just employers located in New Jersey. So it's any employer doing business in New Jersey, employing people located in New Jersey, or just hiring or taking applications from New Jersey. So if that's you, if you have more than 10 employees and you know your advertisements are in New Jersey, you need to make sure to comply with this. But again, it's similar in terms of what needs to be disclosed with the wage ranges and benefits and compensation programs. I also flagged at the end here that proposed rules are being looked at in New Jersey, similar for Connecticut, right? This is a very new law, so we do expect rulemaking and additional guidance on exactly how the law is to be interpreted. So make sure to be kind of monitoring those DOL updates for any actions taken in that respect in the states that will apply to you. And with that, I will turn it over to Hannah.
Thanks, Liz. I'm Hannah, and I'm an associate in the Labor and Employment Group. Cyrus and I are going to walk you through Connecticut's new AI employment law. So I will first walk you through sort of the core framework of the law itself, and then Cyrus is going to dive into a little bit more of the nitty-gritty, and then we'll sort of put Connecticut in context with some other states, like some of the others have been doing. So Public Act 2615 was signed into law on June 2nd of this year as part of a broader online safety and AI bill. I want to flag at the outset that the compliance timeline here is staggered. So some of the provisions took effect immediately or will take effect this October. But some of the most operationally intensive obligations, so the ones that are going to kind of require you to build out new processes and update your contracts and things like that, don't kick in until October 2027. So you have sort of a planning opportunity. You have about 14 months from today before some of the heavier compliance burden arrives. So as we go through, you should be thinking about what pieces need your attention right now, but what you can sort of build on towards over the next year. Next slide, please. Okay, so the foundational concept in this law is the Automated Employment-Related Decision Technology, or AEDT. So this, under the statute, this means any technology that does two things. So first, it processes some sort of personal data, and second, it uses a computation to generate some sort of output. So that can be like a prediction, a recommendation, a classification, a ranking, really any kind of information that's a substantial factor that's used to make or influence an employment-related decision. And critically here, the definition of employment-related decision is really broad. So a lot of other AI policies that or laws that we've been seeing are just sort of focused on hiring, but this covers things like promotion, discipline, discharge, selection for training or apprenticeship programs, and then any other terms, privileges, or conditions of employment. So this definition is sort of a catch-all definition and really used to encompass most aspects of employment-related decisions. I specifically point this out because New York City's law, if some of you know about that one, only covers hiring, promotion, and screening. So this one really is reaching much broader and sort of looking at a lot of different areas within employment. So practically, you should sort of be thinking about what tools might qualify in your organization here. So examples could be things like resume screening tools, if candidates are ranked using algorithms, performance management software, automation promotion engines, anything that's sort of helping you make employment-related decisions is likely covered. And even if you're sort of sitting here and thinking, I don't use any of these, my company doesn't use any of these things, things are moving very quickly, and it's very possible that tomorrow you might decide that this is an important thing to implement. So these are all things that everyone should be sort of paying attention to right now. Next slide, please. So the Act creates two categories of regulated parties, and that determines what your compliance obligations look like. So the first group is deployers, and this is an entity that puts the technology into use. So for most of you, this is going to be you as the employer. If you're licensing an AI-powered hiring tool or some sort of performance management system and using it to make decisions, you're a deployer. And then there's developers. So a developer is the entity that develops or substantially modifies the technology. So this is sort of like HR tech vendors or the companies that are building and selling these tools. It is possible to be both. So if your organization has sort of an internal data team that's building custom models or algorithms, you could be both a developer and a deployer, and so you'd pick up obligations sort of under both of those categories. Deployers bear sort of the primary notice and disclosure obligations to employees and applicants, and then developers have their own set of duties, which I'll cover in a second. Next slide, please. So this is sort of the heavy lift, and that's going to take effect October 1st, 2027. So again, we have about 14 months to prepare, but these are sort of your notice obligations. So there's two distinct requirements. The first is that what I'll call sort of like the interaction disclosure. So if you're using some sort of system that's intended to interact with an employee or an applicant in Connecticut, so some sort of chatbot that conducts some kind of initial interview screen or something like that, you have to disclose in plain language that the person's interacting with automated technology. There is an exception here. It's that you don't need to make the disclosure if a reasonable person would find the interaction obvious, but you kind of have to be careful relying on that because obvious is going to be really context dependent. We think that could be an area that could be potentially litigated as to what that means. The second obligation is the pre-decision written notice. So this is triggered when the output is used to influence or to make an employment-related decision. So before making the decision, you have to give the individual notice that identifies three things. So one, the tool's use and purpose, the trade name of the tool, and any categories and sources of personal data that the tool used to analyze to help make that decision. So one sort of important thing to point out is that this notice obligation is only triggered if the tool was specifically advertised, marketed, sold, or licensed to be specifically for an employment-related decision. So if you're using sort of a general purpose tool or something that just happens to sort of touch employment data, this won't be triggered, but the trigger is whether the tool was actually positioned either by the vendor or by your own configuration as sort of an employment decision-making tool. Next slide, please. So three important points on the developer side of the equation in case we have anyone here that could impact, and it's also sort of helpful for the employer to know what a developer's obligations are. So developers have an affirmative information duty. So they have to provide the employer with the information that they need to satisfy notice and disclosure obligations. So if your vendor won't tell you what data categories their tool is analyzing or how the tool's outputs are generated, that's a compliance problem for them under the statute. Next is contractual allocation. So the Act does allow developers and employers to sort of allocate some or all of the employer's notice obligations to the developer, but you have to be really clear which duties that the developer is assuming. And then third, there is a trade secret safe harbor. So a developer or a deployer can withhold information that it constitutes as a trade secret. So essentially, a quick example is if you are using an AI resume screening tool and your pre-decision notice needs to explain what data the tool analyzed and how it works, but the vendor's sort of algorithm uses a formula that they consider to be a trade secret, you don't have to reveal the formula within this notice, but you have to say something like certain aspects of the tool's scoring are withheld as trade secrets of the technology provider, just so that the applicant knows that something is being held back, and that they're, even if they don't get that information itself. Next slide, please. So just quickly to go through this timeline, Cyrus is going to sort of dig into these a little bit more, but October 1, 2026, that's less than 2 months from today. That's when the core sort of framework takes effect. October 1st, 2027 is when the interactive disclosure obligation, pre-decision written notice obligations that we just discussed go live. And then there's also a grace period that you should know about. So through December 31st, 2027, the Attorney General has to provide a 60-day cure notice before they bring any kind of enforcement action. So there's sort of a built-in soft landing, but after that date, there is no cure opportunity. So I'll hand it over to Cyrus.
Great. Thank you so much, Hannah. Great intro on the AI front. I'm Cyrus Cheslak. I'm an associate in Veral's Labor and Employment Group. And I'm discussing some of the additional obligations and potential pitfalls for employers of using AI products under this new Connecticut law. Next slide, please. First, simple but important, AI is not a defense. Connecticut has made clear in this statute that an employer cannot avoid responsibility for a discriminatory employment decision by saying the algorithm did it. The definition of employment-related decision, as Hannah mentioned, is exceptionally broad. It's designed to apply to most, if not all, employment decisions. If it materially influences hiring, promotion, discipline, discharge, training, terms, conditions, privileges of employment, the employer will remain accountable for the outcome of using the AI products just as if they did it themselves. And a few kind of common and emerging examples of this technology is AI tools for screening resumes, candidate rankings, performance management software, automated promotion engines. One likely scenario where this statute is likely to come up is in a disparate impact analysis. So if a vendor tool ranks candidates, filters resumes, or recommends who should move forward, that outcome has a disparate effect on a protected group, the employer should expect that it may have to answer for that result, even if the tool was built by a third party and even if the employer did not intend any discriminatory outcome. The big compliance takeaway from this is to build internal governance around these tools before they're deployed. Work to understand the tool's data inputs, the criteria, the weighting, and the vendor testing that has gone on before these systems are available to you as a user. And get the data from the vendor when you can in writing about how they've done anti-bias testing with their models, as that may ward off potential claims down the road, as shown in the next slide, please. This is a law, so there's always exceptions. AI is not a defense, but Connecticut does leave room for courts and commissions to consider mitigating evidence. In other words, an employer may not be able to avoid claims completely by pointing to the AI technology it used, but it may be able to reduce its risk or wholly defend the claims by showing that it took proactive steps to prevent discriminatory results by using active anti-bias measures, such as bias testing, validation studies, vendor audit and material analysis, documenting job-related criteria, and reviewing the outcomes of these searches periodically. For employers, in many ways, this means that the documentation of the use of these tools matters almost as much as the use of the tool itself. If a company uses an AI-driven screening platform, it should be able to explain why the factors are used in the tools and how they're job-related, how it was tested, and how it either mitigated or monitored to prevent adverse impact concerns. There's also some contractual interplay with vendors here. Employers should look closely at their agreements to determine whether the vendor is required to perform audits or provide that audit information, whether the vendor will assist with notices or compliance obligations, and whether there's a meaningful indemnification or other risk allocation baked into the contract should liability arise down the road. The broader message here is that AI governance does not sit in silos with HR and IT and legal. It really requires coordination between all three. It reminds us that while AI can certainly help speed things up on the front end, it absolutely pays to verify and use diligence throughout this using that technology. So for employers, the practical question is not only whether you're using AI, but whether and how those AI outputs are actually influencing employer decisions about people, that is, employees and prospective employees. Next slide, please. In addition to the non-discriminatory requirements of this new statute, it also creates a new category of whistleblower protections related to major AI risks. The law is aimed primarily at frontier developers, which are kind of leading entities, as Hannah explained, rather than typical employers who are using commercial AI software. The frontier developers may not retaliate against employees who report unlawful conduct, unethical practices, mismanagement, abuse of authority, or activities that pose specific and substantial danger to public health, safety, or pose catastrophic risk. The practical takeaway is that this is a new protected category of internal reporting. It may be slightly narrower than it seems at first pass. It is not intended to convert every complaint about workplace AI into a frontier developer whistleblower claim. The focus there is really on high-risk AI development, catastrophic risk, large-scale economic damage, personal injuries, examples like AI models sneaking out of a lab unnoticed by humans, other types of big and concerning events like that. Employers in the AI development space should really need to work to develop internal reporting channels and are prepared to receive these concerns. Large frontier developers, that is 500 million in gross revenue in the previous year, starting in 2027, will need to have a reasonable and anonymous complaint process for these types of AI risks. Next slide, please. Whistleblowing and discrimination claims are employee-level changes, but the statute also imposes new disclosure requirements on employers for reductions in forces. The Federal WARN Act generally requires covered employees, 100 employees or more, to provide advance notice of plant closings and mass layoffs, and to file notices with their relevant state agencies, which help with unemployment insurance, employment placement, things like that. Here, that would be the Connecticut Department of Labor. This amendment adds to the WARN Act's existing disclosure requirements for filing with the Department of Labor that employers must disclose whether the layoffs are related to the employer's use of AI or other technological change. Now, the phrase related to is quite broad and it creates a lot of uncertainty. And in one sense, many workforce reductions are influenced through technology automation or other changing business practices. But the question of how related to is a potential point of litigation. The clearest example probably is where AI or automation replaces work that was previously done by employees, like customer service, support functions or automated tools. But it's unclear how directly a reduction in force needs to be to trigger this reporting requirement. If you need WARN Act counsel, this is another issue to discuss with counsel at that time. Essentially, employers planning reductions in force should put this question in the WARN Act analysis early. Is AI driving this reduction in force or not? So that information can be passed along accurately to the state. Next slide, please. So enforcement of the new statute, the AI disclosure provisions Hannah mentioned are treated as unfair and deceptive trade practices in Connecticut, but enforcement, and this is important, is assigned only to the Attorney General. So there's no private right of action for individual employees under these disclosure provisions. Employees may still have other claims for discrimination or retaliation laws, but the disclosure enforcement mechanism itself is for the Attorney General's office. And as Hannah mentioned, there are some safe harbors built into this statute. A temporary cure mechanism exists through the end of 2027. If the Attorney General determines a violation has occurred and is curable, the employer may receive notice and an opportunity to correct the issues within 60 days before an enforcement action is brought. That cure period should not be treated as a reason to wait, but should spur immediate action. Employers should use the runway to build compliance processes now, especially because the notice obligations phase in and will require coordination with vendors, HR systems, and other applicant-facing processes. And with that, I will turn it back over to Hannah to discuss how states are handling some of these issues.
So I know we have less than 60 seconds sort of until our hour is complete. So I'm going to sort of just hit the main topics. We will be sending these materials, so it'll be important to kind of turn back to this and look, especially if you have employees in other states, so that you can sort of make this determination. But the key takeaway is that unfortunately, all of these laws use different language and none of them sort of go together. So you have to sort of navigate all of these simultaneously. When one tool might fall within one, it won't fall with the other. So you have to sort of like do some research and really dig into what all of these states sort of require. Next slide. So this is sort of a comparison table that you can go back and take a look at, sort of highlights what some of the laws have and what others don't. Next slide. So the practical takeaways, essentially just you will want to kind of classify your framework within all of these different statutes. But again, please reach out to any of us if you have any questions. We're happy to sort of walk through each state's laws with you. Next slide, please. And I'll pass it back to Tawny and or Liz.
Yeah, so as Hannah mentioned, there are some more AI slides. So when you get your packet, you'll see those. They're all self-explanatory, but primarily with a focus on if we see federal AI legislation, there's a chance that that could overarchingly, result in each of these state actions kind of being non-applicable based off of preemption. Additionally, in the slides, if we go to the next slides, you're going to learn a little bit about the Workplace Heat Safety Task Force, which is state created, as well as on the next slide, the Connecticut Minimum Wage Task Force. We want to be super mindful of everyone's time. We know we're already 2 minutes early over, and we do apologize for that. I'll turn it over to Andrew just to close us out, but we definitely appreciate everyone's attendance today.
Thanks, Tawny, and thanks to the panelists and attendees. If you have any questions, please don't hesitate to reach out to any of us, and we'd be happy to discuss further. Thank you very much for your time.